Good morning. This is a short video clip based on this morning's session, and the aim of the session is to give all students guidelines on P6 and 7, and hopefully at the end of this presentation you would understand all the basic legal principles to help you complete this assignment. The fortunate thing is that most of the information you can gain from what we did in P4 and 5. We're looking basically at the remedies available to someone who enters into a contract but suffers some kind of disadvantage, such as a contract being broken. So the first point we need to have a look at is consumer rights based on the Sales of Goods Act 1979. There are various amendments made by the Consumer Rights Act 2015. So the first point, as mentioned in P4 and 5, is to discuss the relevance of Section 12 of the Sale of Goods Act 1979. And Section 12 is a very simple basic promise from the seller of goods that they have the right to pass on good title to any possible consumer. This simply means that the seller is the true owner of anything they sell to a buyer. The implication of that is that anybody who buys an item from the seller gets good title. Nobody else can claim the goods from the buyer if the seller has good title to goods. The second section is Section 13, and the importance of Section 13 deals with where consumers have purchased items that they haven't physically seen or examined. What this means is that if you buy items over the internet, or you see items or goods in a catalogue, for example, because you've not physically examined the goods that you've seen, the seller might describe the items to you through the written script of a catalogue, or describe it online, for example. eBay is a very good example of purchasing goods that you've not actually physically seen, but the goods have been described via a picture or words describing what you're hopefully going to buy. Section 13 again is another promise from the seller to the buyer that the goods are going to be exactly as described. So whatever the description is on eBay or in a catalogue, when you receive those goods will be exactly as you expected them to be. If they are any different, then it means that you have possibly a remedy in contract law. It would mean there would be a breach of Section 13 of the Sales of Goods Act 1979. The next point we need to have a look at is Section 14. Section 14 subsection 2, as I mentioned before, is a very important consumer right. And the basic relevance of Section 14.2 is that all goods sold have to be of satisfactory quality. And aspects of satisfactory quality even include the durability, sometimes the packaging of whatever you buy. But I think the basic principle under Section 14.2 is that if you buy an item, then it normally has to last a reasonable amount of time. And it has to be good enough during that period that you're enjoying the particular good. If you buy a bicycle, if you buy a shirt, then the seller promises that those goods will be of satisfactory quality. And if they're not, then again you might have a remedy in contract law. Section 14.3 of the Sale of Goods Act 1979 is very similar to Section 14.2. This means that if you purchase an item and you describe the reason why you're purchasing a particular item, then the item sold to you by the seller has to be fit for all its purposes. So if you buy a pair of trainers and you clearly state to the seller that you need the trainers for running, if you use the goods for running or the trainers for running and they're not good enough, then there's a clear breach or a possible breach of Section 14.3 of the Sale of Goods Act. The goods are not fit for the purpose for which you need it for. And this means that again you can claim a remedy. Section 15 of the Sale of Goods Act 1979 is to do with sale by sample. Every now and again we purchase items by sample. It might be in the supermarket where you taste a piece of cheese and you buy some more cheese because the sample you've tasted meets your requirement. If the bulk that you buy doesn't meet the sample or the quality of the sample that you tasted in the first place, then you have a remedy, a possible remedy, because it will be a breach of section 15, where what you've purchased or the sample that you tasted is not quite the same as the bulk that you eventually bought. And it's very important that as consumers, we're all aware of these various sections of the Sale of Goods Act. And in particular, for this assignment, it will be very important that you understand how to apply the rights that you have as a consumer. The main essence is to put all these details in a leaflet form. What we're doing next is moving on to remedies. Another word for a remedy is a solution. So if you buy an item from a shop and it's not of satisfactory quality, it's not fit for purpose, then you want a solution. The most basic solution most people want is another good or another item which meets their needs. Sometimes you might ask for your money back, and these are all examples of remedies we have in contract law. However, it's very important to understand that there are certain restrictions in the amount of compensation that you might claim. That is actually referred to as remoteness of damages. In simple terms, it means that what you're claiming is too far removed from the original contract, for example. So if I decide to buy a car, and the only reason why I'm buying that car is to use it as a taxi. However, when I purchase the car, I don't tell the seller that I need the car as a taxi. If there's anything wrong with the car, I can claim compensation for the actual car. However, I cannot claim compensation for the money that I would have made had I got the car in time to use it as a taxi. What the courts would say is that you can claim for the actual car, but for the money that you would have made if you had the car to use as a taxi is too far removed, it's too remote, and therefore you wouldn't be able to claim damages for the money you would have gained had you used the car as a taxi. That's the restriction that the law imposes on remedies or damages available in contract law. So remoteness of damages simply means that sometimes the courts will limit the amount of damages you're entitled to. It will only allow you damages which are close enough to the original contract and not any other losses that are far removed, for example, as I gave in the taxi example. Compensation, as I mentioned before, is an obvious remedy or solution in contract law. It simply means that the courts will try as much as possible to put you back into the position you would have been in had the contract not been broken. So if you buy a shirt and it's not good enough, then you either get the value of the shirt or another shirt. In other words, you're not in any worse position, and the assumption is that you're in a similar position as if the contract hadn't been broken at all. So compensation simply means money that will put you back in the position that you would have been in had the contract not been broken. Nobody loses in this case. An injunction is another remedy available in contract law, and an injunction is also what we call an equitable remedy. You can have positive injunctions. A positive injunction will be where you're required to do something. So normally, in family cases, a spouse might be required to pay a certain amount of maintenance money to a child or a mother. That's a positive injunction. Again, using a family law example, you might have a negative injunction. That stops you from doing a particular thing. So if you've been violent towards a partner, then it might stop you from going anywhere near that individual. So an injunction is an equitable remedy, and the courts will only allow that particular remedy, an injunction, if they feel it's fair. The next remedy that we're going to look at is specific performance. Specific performance is another equitable remedy, and it simply allows you to, or it forces the court to require, for example, a seller to do what they promised. So it's like the court telling you that you made a contract with Mr. X, make sure that you carry out that particular contract. Don't pull out from the original contract. And this tends to happen in the buying and selling of land. So if you find a house that you like and you make an agreement with the seller, and then the seller decides to sell it to another person because the other person has offered them more money, then the idea here is that the courts will require the seller to sell to you as the original purchaser. And that's what specific performance is all about. A court order forcing the seller to honour the original contract rather than offering the sale to somebody offering more money. Mitigation of loss is another aspect of remedies, and it simply requires that the person who is not in the wrong should make every effort to make things better. So if I order 100 bags of sugar, for example, and the seller doesn't deliver those 100 bags, in theory I could sue them and ask for my money back, but what the courts would want me to do is to mitigate or lessen my losses. So even though I'm in the right and I've not done anything wrong, the courts will require me to go and buy the sugar elsewhere, which means that I'm doubling the expense that I have. However, if I do that, the courts are more likely to award me compensation based on the previous sale that I didn't receive. So mitigation of loss simply means to make things better, even though I haven't done anything wrong in a contract. And in sum, or to summarise the key points, talk about the remedies available to a consumer, and talk about the rights you have under the Sale of Goods Act 1979 and the Consumer Rights Act 2015 as amended. And don't forget to put all your information in a leaflet form. Thank you for watching this short clip.